It's my pleasure now to introduce the keynote speaker, Judge William Fletcher, a judge on the U.S. Court of Appeals and for the Ninth Circuit. A former Rhodes Scholar, Judge Fletcher worked for the Office of Emergency Preparedness in the Executive Office of the President from 1970 to 1972. He clerked for Judge Stanley Veal of the U.S. District Court in San Francisco and for Justice William J. Brennan of the U.S. Supreme Court before joining the faculty of the University of California, Berkeley School of Law in 1977. In 1992, Judge Fletcher was the Northern California Director for President Clinton's campaign. He has been a visiting professor at Stanford, Michigan, and the University of Cologne, and he has taught at the Salzburg Seminar on American Legal Institutions. Judge Fletcher received the UC Berkeley Distinguished Teaching Award in 1993. He is the co-author with Professors Jeffrey Hazard and Colin Tate of a civil procedure casebook. I can also tell you that Judge Fletcher received his BAs from Harvard University and Oxford University and a Juris Doctor from Yale University. Judge Fletcher.
Thank you very much for that generous introduction. I'm flattered to have been asked to deliver the introductory talk to this distinguished group. I will begin with an old joke. Late at night, a man comes upon someone looking for something under a streetlight. The man asks, "What are you looking for?" "My wallet." "Did you lose it here?" "No, I lost it down the street." "Why are you looking here?" "The light is better." This could be a joke about American legal education. Christopher Columbus Langdale is famous for having invented the case method of legal instruction, beginning with the first edition of his contracts casebook in 1871. He was the dean of the Harvard Law School for 26 years, and by the turn of the century, the case method of instruction had caught on in the newly emerging academic law schools in the United States. The case method, at least in its original form, self-consciously treated published judicial decisions as the equivalent of scientific specimens from which, if properly understood, enduring general principles could be distilled. With the advent of the modern case reporting system under the West Publishing Company in the late 1800s, published decisions were available to anyone with access to a decent law library. The law library with its case reports became legal education's equivalent to the illuminated space under the streetlight. The case method caught on just as legal education in the United States was completing its move into university classrooms from apprenticeships in law offices. As the study of law became more academic, it became increasingly separated from the world of practicing lawyers and judges. The casebook editors, I hardly dare call the early ones authors, gathered judicial decisions for their students to study, but the cases were selected and edited to illustrate particular doctrinal points. The professors, particularly in the elite schools, came to practice law less and less, indeed often not at all, before entering the library and the classroom. I do not want to spend a great deal of time describing the ways in which the world of academic law has become separated from the world of practicing lawyers and judges. I will say only that the gap between the academy and the profession that began to appear at the end of the 19th century has persisted in various forms into our own time. There is another gap. Not only is there a gap between the law schools and the profession, there is also a gap between academic law and other academic disciplines. In one sense, the gap is surprising, for law touches pretty much all of human experience, birth, death, and everything in between. If our laws are going to discourage or encourage, prohibit or allow various forms of human behavior, those who study our laws should understand that behavior. But in another sense, the gap is not surprising, for sustained interdisciplinary studies are notoriously difficult. Neuroscience and law is one such interdisciplinary study. I will come back to neuroscience at the end of this talk, but first I want to examine two disciplines, indeed almost the only two, that have managed to bridge the gap in the last three-quarter century. They are psychology. Here I will blur the licensing distinction between psychology and psychiatry, and economics. Psychology has had some success. Economics has had enormous success. First, psychology. I still remember my reaction in law school when I read Jerome Frank's Law and the Modern Mind. It had not been assigned. I ran across a reference to it in something else I was reading. I was in law school in the early 1970s. The book was published in 1930, but it spoke to me with a clarity and immediacy that thrilled me. Frank was intrigued by Freud and Piaget, particularly Piaget. His thesis, elaborated over the course of 300 pages, was that law serves as a father substitute. I reread the book 2 weeks ago in preparation for this talk. The thrill, I'm afraid, was gone. I know more now than I did then. Even though its insights now, 80 years after its publication, seem in many ways obvious, it is still a fascinating and valuable book. The insights of psychology, and in particular psychoanalysis, have also had more on-the-ground applications. There are obvious applications in criminal law. The mental state of a criminal defendant is relevant in a number of ways. The mental state at the time of the crime, in lawyers' Latin, the mens rea, is relevant to a determination of the type of crime, for example, whether it is first or second-degree murder, that the defendant may have committed. Mental state is relevant indeed to whether there was a crime at all. That is the defendant not guilty of any crime by reason of his insanity? It is relevant to the competency of a defendant to stand trial. Under American law, a criminal defendant cannot be made to stand trial if he is incompetent to participate in his own defense. Finally, mental state is relevant to the punishment of a convicted defendant, most notably in capital cases, where a separate penalty phase trial is held if a defendant has been found guilty of a death-eligible murder. One of the most famous attempts to bring new psychological knowledge to bear on a legal question was the 1954 decision of the Court of Appeals for the D.C. Circuit in the Durham case. Durham was mentally ill and had been convicted of housebreaking. Judge Bazelon took Durham's appeal as the occasion to reformulate the insanity test to be more favorable to the accused. I'll say as an aside, I'm not at all surprised that Judge Bazelon chose a housebreaker rather than an axe murderer to be the beneficiary of the new test. The D.C. Circuit had followed a version of the so-called right-wrong insanity test derived from the English McNaughton test decided in 1843. Citing academic and professional literature, Judge Bazelon disregarded the McNaughton rule, under which a defendant had to show that he did not understand, quote, the nature and quality of the act he was doing, close quote, or did not know that the act was, quote, wrong. The new test, announced in the Durham case, is as follows, quote, an accused is not criminally responsible if his unlawful act was the product of mental disease or defect, close quote. In justifying the new test, Judge Bazelon wrote, the legal and moral traditions of the Western world require that those who, of their own free will and with evil intent, sometimes called mens rea, commit acts which violate the law, shall be criminally responsible for those acts. Our traditions also require that where such acts stem from and are the product of a mental disease or defect, moral blame shall not attach, and hence there will not be criminal responsibility. This was, for those of us who are familiar with American criminal law, very much a period piece. The insights of psychology were also brought to bear on family relations. Dr. J. Katz and Joseph Goldstein, both professors at the Yale Law School, and both trained as psychoanalysts, focused their scholarly energy on family law. Their most famous contribution is probably summarized in their phrase, quote, "the best interests of the child." Stated simply, they advocated that in child custody cases, the interests of the child, rather than those of the adults, should be paramount. For example, in their view, if a child became psychologically attached to grandparents or foster parents through a prolonged period of living with them, the child's attachment to them should weigh heavily in the balance against asserted custody rights of the birth parents. Though it's not strictly relevant, I note that Professor Goldstein had been a law clerk to Judge Bazelon the year before the Durham case was decided, and he'd prepared a number of the memoranda upon which Judge Bazelon relied in writing that opinion. There are other examples of psychology influencing the academic study of law and influencing the law itself, but those are probably the two most prominent, and for our purposes, they will serve the purpose. Second, economics. Our law has always been concerned with the monetary consequences of actions. Law and economics, as we conceive of it today, was born in Chicago, almost fortuitously, in the early mid-20th century. Henry Simons, a professor in the economics department, was in trouble with his colleagues at the University of Chicago. He retained his position as a professor in the economics department only with the support of his friends in the law school. And sometimes in the 1930s, he was given a half-time law school appointment. Simons was then instrumental in bringing the extremely talented economist, Aaron Director, to the Chicago Law School at the end of the Second World War. The Journal of Law and Economics was founded at Chicago by Director in 1957. Professor R.H. Coase published his famous article, The Problem of Social Cost, in that journal in 1960, 3 years later. For those of you unfamiliar with the article, I'd like to give you the quickest of summaries. In other words, I want to give you a little sense of what economics and the law has been. Then conventional economic analysis liked to assume the presence of perfect information and the absence of transaction costs. An economic model based on those two assumptions predicts that trading will take place such that the most efficient use of economic resources will result. For example, if a steam train engine gives off sparks and occasionally sets adjacent farm fields on fire, the question arises whether to make the train owner or the farmer bear the loss. If the two assumptions hold true, the train operator and the farmer will bargain between themselves to determine whether to put spark arresters on the chimney of the engine, whether to burn better coal, whether to leave larger margins at the edge of the track, and so on. The result of their bargaining will produce the most economically efficient resolution of the competing interests. That's the theory. Coase's contribution was to insist that transaction costs could not be ignored. That is, in the real world, transaction costs are always present and are often so large that the hypothesizing bargaining to an efficient result never takes place, or takes place under severe constraints. Thus, the placement of the initial liability on the train owner or the farmer can make an enormous difference in determining whether the ultimate solution to the problem is economically efficient. Professor Guido Calabresi took this basic insight and applied it to automobile accidents in his 1970 book, The Cost of Accidents. Calabresi's solution to the problem of transaction costs was to try to figure out ahead of time who could avoid the accident at the least cost, and then to impose liability as a rule of law on that person. Hence, Calabresi's famous phrase, quote, least cost avoider. When I went to law school in the early 1970s, Coase and Calabresi's ideas had become staples of legal education. We learned them in torts class, we learned them in property class, we learned them at lunch. But Chicago-style law and economics was not entirely welcomed in the academy. There were several reasons for this. Among them was the lack of familiarity of many senior law faculty members with economic analysis, combined with their comfort with old-style case analysis. A more important reason for many, however, was the nature of the economic analysis itself. Much of the early law and economics analysis, though not that of Coase and Calabresi, was grounded in unrealistic assumptions of laissez-faire market efficiency, which for many coincided with devil-take the hindmost political conservatism. Beginning in the 1970s, corporate-funded private institutes were established with the express purpose of inviting federal judges to all expenses-paid seminars explaining economic principles, particularly those of free market economics. The most famous of these was the seminar of Professor Henry Manny in Florida, but they continue. I'm now invited every year to attend an all-expenses-paid economics seminar in Bozeman, Montana, at the Foundation for Research on Economics and Environment. Foundation F, Research, Economics, Environment, FREE. It's called free, and there's no, it's a typical American sort of acronym. The invitation says conference and travel expenses are paid and ample time is provided for cycling, fishing, golfing, hiking, horseback riding. In the words of free, the lectures, quote, emphasize property rights, market processes, and responsible liberty. Some judges go to these, both conservatives and liberals. They're paid for with the hope that the judges will become indoctrinated into this way of thinking and to some extent this political environment. I have never gone. I prefer to pay for my own cycling and fishing, and I don't golf. In recent years, some law and economic studies have moved away from their laissez-faire Chicago roots, both in economics itself as well as in law and economics. There is now the study of what has come to be called behavioral economics, or if you follow popular literature, freakonomics. Behavioral economics brings actual human behavior, in the terminology of economists, non-rational behavior, into the equation. For example, neoclassical economics tells us that a widget has the same value to me whether I already own it or whether I am about to buy it. In either case, it's the same widget and has the same value. Behavioral economics, however, tells us that people will ordinarily charge more to sell a widget that they already have than they will pay to obtain a widget that they do not yet have. Another example, behavioral economics tells us that people regard sunk costs as relevant to future expenditures, however economically irrational that might be. The folk wisdom, of course, already tells us that, telling us don't throw good money after bad. One can readily see that the behavioral economics here are poaching on what might have thought was the territory of the psychologists. To give a rough sense of the comparative degrees of academic synthesis of law and psychology on the one hand, and law and economics on the other, I asked my law clerks to look at the non-law degrees held by professors at 6 major law schools in the United States. Yale Law School, 1 faculty member with an MD. And for present purposes, I am counting, I may be inaccurate, but roughly speaking, it's going to be right. And for present purposes, I'm assuming that a faculty member on a law school faculty with an MD is a psychiatrist. So Yale, 1 faculty member with an MD, 8 faculty members with PhDs in economics. Harvard, 1 faculty member with an MD, 8 faculty members with PhDs in economics, exactly the same as Yale. Stanford, 1 PhD in psychology, 8 PhDs in economics. Chicago, no surprise, no MDs, no PhDs in psychology, 5 PhDs in economics. The smaller number is accounted for not by the relative disinterest in economics in Chicago, but by the small size of their faculty. Bold Hall, the law school at the University of California, Berkeley, 2 PhDs in psychology, 9 PhDs in economics. The 2 rather than 1 are accounted for by both separate course incorporated into the law school that they call jurisprudence and social policy. So there's a substantial and deliberate emphasis outside of law itself. Finally, University of Pennsylvania Law School, 2 MDs, 2 PhDs in psychology, and 9 PhDs in economics. The only explanation I have for Pennsylvania being an outrider is the perspicacity of its faculty. Why the great disparity between economics and psychology? I can venture a few guesses. First, law schools pay their professors more than economics departments. Economics professors are, to use an economics word, incentivized by money, both personally and professionally. Second, economists don't ordinarily have much need for laboratories. An office and a computer will usually do the trick. Third, once 2 or 3 economists come onto a law faculty and work in the same building, there is a symbiosis of friendship and intellectual exchange, making space for even more economists, kind of a theory of breeding pairs. Fourth, most economics is pretty easy for a law professor to understand. And then, none or almost none of these conditions, with the exception of money for psychology professors, apply to psychology. Further, early psychology and law study in the academy was heavily influenced by psychoanalysis. And as psychoanalysis has fallen out of favor in the world of psychology, it has similarly fallen out of favor in the world of law schools. I'm tempted to say, in addition, that economics applies to a wider range of legal issues than psychology, but I don't think that's true. It may be true that economics has application to a wider range of interest with which the major law schools are concerned, but that's a different question. Psychology has the most to offer, as suggested by what I've said above, in fields like criminal and family law. Criminal law is viewed as an important subject in the major law schools, but the number of law faculty slots devoted to the subject is relatively small. Family law should be, but is not, typically regarded as an important subject to which substantial faculty resources should be devoted. And this attitude toward family law has changed a little in recent years, but not very much. What, if anything, does all of this have to say about the prospect for law and neuroscience? What are the chances of a long-term, sustained, interdisciplinary study of law and neuroscience? Neuroscience, I'm afraid, looks more like psychology than economics. Neuroscientists need labs. They will not ordinarily have offices down the hall from law professors, or if they do, they won't spend much time in them. There will not be that many neuroscientists interested in law, and not that many law professors interested in neuroscience. The disciplines of law and neuroscience are very dissimilar, so both sides have to do a lot of work to understand one another. I will say that the political bias that has proved a problem for economics is not likely to be as substantial for neuroscience, but that's pretty thin gruel. In other words, a lot of work and dedication is going to be required if we are to have sustained interdisciplinary work in law and neuroscience. If we do see a successful synthesis of the two disciplines, what are we likely to see? I'm going to start with a frolic and a detour. New scientific fields often experience what I might call exuberant, maybe extra exuberant growth. For example, in the early days of electricity, all sorts of things seem possible. Give a little boy a hammer and the world is suddenly full of nails. Give us electricity and the world is suddenly full of electric belts. In the mid to late 1800s, when our understanding of electricity was still in its early stages, a number of medical uses were thought, at least by some, to be served by electricity. There was a substantial market for electrified belts. The belts went around the waist, sometimes reaching down with a flap to cover the genitals. They gave the wearer mild electrical shocks, the more expensive ones, greater shocks. These belts cured, according to the literature advertising them, among other things, stomach upset, constipation, diarrhea, flatulence, paralysis, cough, epilepsy, heart disease, asthma, sluggish liver, and loss of vigor, vim, and vitality. The V word in Victorian medical parlance referred to sexual function. Think Viagra. We cannot, I'm afraid, expect such exuberance from the uses of the new science of neuroscience, but maybe we can hope for at least a few miracle cures or miracle correlations. One sign that such exuberance might exist is a recent article published by Vahl, Harris, Winkleman, and Pashler in the Perspectives on Psychological Science in 2009. They softened the title for ultimate publication, I guess because of academic sensitivities. They were criticizing correlations found between fMRI results and various emotional states. I won't give you their later softened title. I'll give you their original title, which captures it better. It was originally called Voodoo Correlations in Social Neuroscience. So maybe there's a little hope for some equivalent of the electric belt. We shall see. Well, what might be the uses of neuroscience when applied to legal problems? The list is pretty long, and I'm sure we'll hear quite a bit about various aspects of this during the next day and a half. In criminal law, the same issues for which psychology was helpful may be helpful in neuroscience. What mental capacity does a person have to intend or to commit a crime? In other words, did the person commit only second-degree murder, or is the person not guilty by reason of insanity? What capacity does a particular person's mind have to feel empathy or to internalize moral structure? In other words, is the person a psychopath? Is the person mentally retarded, as defined by the United States Supreme Court, and therefore ineligible for the death penalty? There are other potential uses outside the criminal law. For example, is the person telling the truth? If a sufficiently reliable test can be devised by neuroscience, it could have use in both criminal and civil cases. Further, could we determine through, for example, an FRI, whether a person has seen a particular place or person before? Again, useful, I think, in both criminal and civil cases. Can we determine someone's mental capacity to sign a will or to make other important legally binding decisions? Can we determine whether a person is feeling pain or is just faking? This can have enormous importance, for example, in both personal injury tort suits and in Social Security disability suits. I could make the list longer, but you get the idea. Across the whole range of human experience and across much of law, neuroscience may have things to offer us. But we have been doing law for a very long time. Since time immemorial, our societies have had to deal with crime, with truth-telling, with family relations, with mental disease and defect. Lawyers and judges and our modern legal system are experienced and fairly sophisticated about these things. The lawyers and the judges may not always talk the language of economics, but they know, for example, that it hurts most people more to lose something than it pleases them to get that same thing. They know, for example, the temptation to pay attention to sunk costs, and the folk saying, they all know, don't throw good money after bad. They know that an insane person cannot be guilty of a crime, but they also know, no matter whether the test is formulated under the old McNaughton rule or under Durham, that juries dislike and distrust the insanity defense. Any lawyer who relies on the insanity defense usually has a losing case. In other words, lawyers and judges who have been dealing with such questions for a very long time seem to have muddled through fairly well without law and neuroscience, just as they have muddled through without law and economics and without law and psychology. One of the most famous books of the 1970s was Judge, then Professor Richard Posner's book on law and economics, in which Judge Posner analyzed at great length the traditional rules of common law and concluded that common law judges were excellent economists in spite of their lack of formal education in the subject. In other words, the judges already spoke prose. I think we cannot expect fundamental change, either in the academy or in the world of lawyers and judges, from neuroscience, any more than we have had fundamental change from economics and psychology. I won't say that they were useless, far from it, but fundamental change, I think, is not in the cards. It will be very much worth the effort for us to close the gaps between the law professors and the neuroscientists, and between neuroscience and the legal profession. We will all learn about ourselves, about our minds, about our law, and about our society. We will get some changes in our actual practices, and perhaps more important, we will get fundamental changes perhaps in our perceptions of our law and in ourselves. I will close with a passage from T.S. Eliot from Little Gidding that seems to me apt, even if a little optimistic. I never thought I would say that T.S. Eliot is optimistic. We shall not cease from exploration, and at the end of our exploring will be to arrive where we started and know the place for the first time. Thanks very much. Ask questions. Oh, that's terrifying. Okay.
Well, we do have a little time for questions, and I'm sure that some of you would like to ask some questions. May I first of all say thank you for such a wonderful lecture, but yes, some questions, please. Yes.
In legal schools right now, what's the current attitude towards incorporating psychology and neuroscience as part of legal?
In legal circles? That's very hard to say because there's great excitement for people who know anything at all about neuroscience, about what can be learned. And I think that excitement, in a sense, is largely independent of law and law schools. It's just very exciting information. Most people, when I say, I'm learning a little bit about neuroscience kind of off to the one side of my ordinary job, they love to hear about it. On the other hand, I think it's fair to say that law schools at the moment have not yet fully understood what's there to be had. A lot of the people here in this room who are law professors are very interested and working very effectively to bring this within the circle of law studies as well as law as practiced. But we're at the beginning stages.
Yes.
Outside of law schools, among practitioners, say in the bar, are there opportunities for people to meet experts outside of the fields they may have been exposed to in law school to start incorporating things?
One of the great secrets of American legal education, I might say one of the great dirty little secrets, is that law school doesn't actually prepare anyone to practice law. And that most lawyers learn to practice law after they get out of school. What then were the purpose of those 3 years? Well, at the Yale Law School, where I was a student, to have a wonderful time reading books like, Law and the Modern Mind that weren't assigned. After you get out of school, you then learn to be a practicing lawyer. And within your field, the other people in your field will tell you. I'll take criminal law because it's the most obvious example. If you've got a capital case and you're looking forward to the penalty phase, and you're trying to figure out what can I possibly put forward as a defense for this man. American capital cases are in two phases. First, is he guilty of a death-eligible offense? If so, then you have a separate trial, usually in front of the same jury, as to what the penalty should be. And the choice at that point is either life in prison without possibility of parole or death. At that second stage, the defense lawyers can put into evidence pretty much everything but the kitchen sink. And any experienced capital defense lawyer will immediately think of neuroscience. Now, it may or may not be available in the particular case, but if that lawyer, for example, can get, say, an fMRI or other form of brain scan that shows or could be at least plausibly thought to show brain damage, that will be introduced. And your fellow lawyers will tell you how to do this. I'll say something a little bit off to one side that I didn't include in the basic lecture. Ordinarily, we've got very different standards for what constitutes good science and good law. And it may be very much that we've got very good science that shows us certain correlations in brain patterns for truth-telling and lying. And it's scientifically valid to say that these are real correlations. We can see it. But it's not a high enough correlation that it's acceptable in a court of law. That is to say, there are very different standards for what constitutes good science compared to legally admissible evidence to show guilt, a lot of guilt, and so on. There's a little bit of the converse, particularly in a capital case. At the penalty phase, I might be quite happy to allow in what might by scientists be considered bad science. That is to say, it may be a leap to say, well, he has this brain pattern, he's not responsible for his behavior, and look at this picture. Well, the picture may not actually be very probative, but depending on one's attitude toward the death penalty, depending on what one might allow the jury to seize on as an excuse to follow through what otherwise might be its instinct, in my view, it might be perfectly appropriate to allow that in, even though a scientist might say, well, you know, I'm not sure that's as probative as it ought to be. And there's some people in this room have had direct experience with this sort of thing. But the short answer is, the lawyers are going to learn about law and science, neuroscience to the extent that it's relevant to them, usually after they get out of law school.
I think many of us would say that we learn our trade after we've had the training.
Yes.
Yes, over there. Thank you.
Yeah, I was interested in you saying that law has muddled through for many decades without economics and without psychology. And I'm just wondering if that's not too strong a statement, because lawyers, I'm led to understand, are kind of human beings, and they grow up in certain cultures, and they are not immune to the beliefs about human beings that are around in those cultures. And psychology has had a very significant presence in most Western cultures over the last century.
Yes.
And it does seem to me that when lawyers think about, for instance, what a child is, or what an adolescent is, or what any other category of person is, they cannot help but think about those in terms that to some extent, maybe not explicitly, pick up on the kinds of beliefs about persons that are around in their culture. So I suppose my question is, they've incorporated certain psychological beliefs into their common sense. And I wonder if you think that at a future moment, they might incorporate some other beliefs about persons, like neuroscientific beliefs, into their common sense as well.
Well, that's a very important perception. And to some degree, I may have simplified in saying, well, we've gotten along fairly well without economics, without psychology. What I should say more precisely is we've gotten along fairly well without the introduction into law of the formal study of economics and the formal study of psychology, because what you say is quite right, and this is the great strength of the common law tradition, that we have judges who are usually appointed fairly late in life, quite unlike the continental tradition, with substantial experience in life, some of it, based on their law practice as commercial lawyers, some of it based upon I had a child who was schizophrenic, or whatever set of experience it is, plus, generally speaking, both American and English judges are well-educated and well-read generally, and they will bring into their decision-making the basic knowledge of the community in which they live. So, and that's been the history of the common law long before these formal academic disciplines were introduced. So I don't mean to say that without sort of psychological insights in the law school, the judges have gotten along perfectly well because they were psychologically ignorant. No, it's that they've picked it up simply by living in the world in any event. So I quite agree with what you said.
Yes, please.
Hi, I was interested in your possible distinction about the admissibility of neuroscience evidence in court. And I wondered if you could just comment on how you think the legal profession might distinguish between how neuroscience data and psychological data may be perceived, and whether there's a difference in that perception.
Judges are saddled with a whole list of rules about evidence, much of them derived from the common law, some of them very precise about, for example, hearsay. There's a hearsay rule that keeps out hearsay, subject to about 537 and a half exceptions, and so on. The most important evidentiary rule, however, for the purposes of neuroscience, is likely to be, well, most going to be two, and I'll give you the federal court equivalent of it. Number one is a Supreme Court case called Daubert, and number two is Federal Rule of Evidence 403. Under Daubert, which is a Supreme Court case, if certain forms of scientific or expert knowledge is sought to be introduced by one of the parties, the judge will have what's called a Daubert hearing, in which the judge will try to determine, based on testimony in that hearing, the state of the scientific knowledge and whether or not the testimony that's coming in is sufficiently reliable from an from a scientific standpoint that it should be admitted. The Daubert hearing is not pro forma; it's a very real thing, and it allows in and keeps out, fair amounts of evidence on either side. It's not infallible. Sometimes junk science comes in anyway, and sometimes actually fairly good expert evidence is kept out, but it works moderately well. The second is Rule of Evidence 403. Rule 403 says the judge will essentially allow in evidence if the judge thinks it is sufficiently probative and not too prejudicial. That's a very open-ended standard, and it's going to be the judge's common sense of, will the jury be unduly influenced by this evidence? And what undue is going to be pretty much in the mind of the trial judge. I review 403 determinations on appeal, and I see them actually quite a bit, for abuse of discretion. I virtually never overturn a 403 determination. And the judge is basically going to set a feel for what's, is this helpful or not? Now, one question, for example, that'll show up, in fact, it shows up a lot in the academic literature right now about neuroscience. It's very clear that test subjects shown pictures of brains will react very strongly to those pictures, and they will believe pretty much any damn thing you tell them if it is accompanied by the picture of a brain. Now, the way the world, in my view, ought to work is that the Daubert hearing will prevent the junk picture from coming in everything except capital penalty phase. There is no Daubert hearing in penalty phase. You can put any damn thing you want in defending your guy against the death penalty. But once it comes in, having gotten past Daubert, the question is, what influence does it have? And I'm actually fairly strongly in favor of allowing in pictures like this, even though they will have, at least in most cases, a fairly strong influence on the jury, because the early situation without the picture is not necessarily the best picture. That is to say, the early situation is not necessarily the best situation. Many people have great trouble understanding the reality of things merely based on words. And if a picture will help them get to the point of fully understanding what is going on, I think so much the better. But it's clearly an issue, and we struggle with it.
Somebody that is a law professor for over 30 years and somebody that litigates science in courts, scientific techniques, I wonder whether muddling through is really good enough. I mean, don't you think we paid an enormous price for the fact that our judges are not really scientifically literate, that really starts in the law schools, such that we have all this forensic science in courts that is not science, and being admitted without any recognition that it wasn't scientifically validated, and in turn, with respect to capital punishment, and I'll profess that I'm against it. Isn't there a danger as well in terms of showing all these pretty pictures of the brain that just as capital lawyers are trying to get life verdicts. At the same time now, the same science, or so-called, perhaps not properly validated science, is going to be used to show, oh, well, this person has a proclivity towards violence, has a brain that makes them violence, and all kinds of predictions about future dangerousness, and this may not be the best thing in the world for the capital community in the long run, or for solid adjudications, or put simply, isn't it better to just try to educate judges and have good science in courts rather than not so good science?
You've raised a lot of interesting and good points. Let me start out with what you started out with, which is to say, what are the strengths and weaknesses of having a generalist judiciary? It is one of the great prides of the American system that our judges are generalists. A federal trial judge handles everything. Antitrust cases, Social Security cases, criminal cases, securities cases. Any judge coming onto the bench will have had professional experience in a fairly narrow range of that with which he or she is asked to deal once on the bench. And every judge will tell you that. That is both a great advantage that they're generalists, because they have a wide range of experience. The longer they are a judge, the more they see, and so on. And it has the corresponding disadvantage. Jack of all trades, master of, well, maybe the one they came in with, but not any of the rest. And particularly when you get to, for example, in criminal cases, all of the so-called forensic evidence, it turns out that a lot of the so-called forensic science is junk science. And here I'm not talking about neuroscience. I'm talking about sort of blood, bite marks, hair identification, even DNA, which can be misused. The test can misfire. DNA is not infallible. It's a great weakness of the system. I'm not sure how much educating judges will cure it, although it will help some. The problem is that problem is probably better resolved, as I think it's in the process of being, I won't say resolved, we're getting improvements. We now have sort of a national study on the, I'm sure you know this, on how weak forensic evidence is, how unreliable forensic evidence is. And of course, there's a doctor in Texas that's just famous for this in death cases, to have his own psychological expert testimony that he looks at the file, he never even interviews the prisoner, and says, oh, I can see from this file that he is never going to be rehabilitated, and if you let him go, he will kill again, and if you keep him alive in prison, he'll probably kill there too. I mean, there is a lot of irresponsible junk science masquerading as testimony, and by no means limited to neuroscience. In fact, I think not particularly neuroscience at all. And how do you protect against it? I wish I could think that education of judges in this science would significantly help. I think it would help some. But it is a very real problem. And I think the root causes and probably most of the cure lies outside of education of judges.
Well, I think that brings us to a conclusion. And I think, this discussion session has really emphasized just how important it is for the two sides, scientists and lawyers, to be talking. Thank you very much.
Thank you.